Hello? Is this thing on? Listen to me. If you are sitting there, thinking, Susie, I have a will. I am fine. My kids will be fine. I can just put my feet up and enjoy my retirement, I want you to wake up. Wake up right now. Because you are making a mistake. A massive, catastrophic mistake that could absolutely destroy every single penny of wealth you have worked your entire life to build. You think estate planning is just a chore for the ultra-wealthy. You think because the federal government changed the laws and pushed the estate tax exemption to $15 million per person, you don't have to worry. Wrong. Estate planning is not about the federal government. It is about control. It is about protection. And most of all, it is about keeping your money out of the hands of the courts, out of the hands of predatory lawyers, and in the pockets of the people you actually love. But let's say you think you've outsmarted the system. You say, Susie, I don't just have a will. I set up a revocable living trust. I am completely protected. Are you? Are you really? Let me ask you the most critical question about your trust. Did you fund it? This is where so many people completely drop the ball. A trust is like a beautiful, top-of-the-line vault that you bought to protect your most precious jewels. It has a digital lock, thick steel walls, and it's completely impenetrable. But if you walk away and leave all your gold, your jewelry, and your deeds sitting on the floor outside the vault, what good is it? It is absolutely useless. When you create a revocable living trust, you have to physically change the titles of your assets. Your home deed cannot say John and Mary Doe anymore. It has to be retitled to John and Mary Doe, trustees of the Doe Family Living Trust. Your non-retirement brokerage accounts, your high-yield savings accounts, they must be owned by the trust. If you buy a new house or open a new account and you forget to put it in the name of the trust, guess where that asset goes when you die? Straight to probate court. The trust can only govern what it actually owns. If you leave the vault empty, your family is going to pay the price. Let's look at another fear that many of you are completely blinding yourselves to: incapacity. You are so focused on what happens after you die that you completely forget about what happens if you live, but you can no longer take care of yourself. What happens if you suffer a stroke, or if dementia sets in, and you can no longer sign your name or make a logical decision? Who is going to pay your bills? Who is going to manage your investments? Who is going to tell the doctors what kind of medical treatment you want or do not want? If you do not have a durable power of attorney for finances and an advance healthcare directive in place, your family is completely paralyzed. Your spouse or your children cannot just automatically step in and manage your accounts, even if you are married. They will have to go to court and petition a judge to declare you incompetent so they can be appointed as your legal guardian or conservator. It is humiliating, it is incredibly expensive, and it takes time you do not have when medical decisions need to be made or bills are coming due. And who do you name as your power of attorney or your executor? Do not just pick your oldest child because of family hierarchy or because you don't want to hurt their feelings. That is a prideful mistake that can ruin everything. Being an executor or a financial power of attorney is a job. It requires organization, attention to detail, emotional stability, and the ability to work with accountants and lawyers. If your oldest child is terrible with money, or if they fold under pressure, or if they have a rocky relationship with their siblings, do not put them in charge. You are assigning them a task that will cause them immense stress and inevitably spark a civil war among your children. Choose the person who is competent, trustworthy, and capable, even if it means having a difficult conversation today. So, what is the actionable takeaway here? What do you need to do right now to make sure your family wealth is protected? First, you need to conduct a comprehensive asset and document audit. Sit down with a legal pad and write down every single asset you own: your house, your bank accounts, your retirement funds, your investment accounts, your life insurance policies. Then, find the paperwork. Look at the beneficiary designations for every single one of those retirement accounts and insurance policies. If they are blank, or if they are outdated, fix them immediately. Second, if you do not have a revocable living trust, you need to get one. If your estate consists of a home and significant savings, a will is simply not enough protection to keep your family out of court. Go to a qualified estate planning attorney in your state, or use a highly reputable, comprehensive estate planning service. Do not use a generic, cheap online template that doesn't account for your specific state laws or family dynamic. Third, once that trust is created, you must fund it. Work with your bank, your brokerage firm, and your local county recorder to transfer ownership of your deeds and accounts into the trust. Do not stop until the paperwork matches the plan. Fourth, make sure your incapacity documents are updated for 2026. You need a durable power of attorney for finances and a healthcare directive. Ensure your doctors and your chosen agents have copies of these documents. Finally, communicate. You do not have to tell your children every single dollar amount, but you must tell them where the documents are located. If you have a password manager for your digital assets, make sure your executor has emergency access to it. If your documents are locked in a safe or sitting in an attorney's office that closed years ago, your plan is useless because no one can find it. Take control of your life. Take control of your money. Do not let your lifetime of hard work be stripped away by negligence. Protect yourself, protect your wealth, and protect the family you love.